should have you guys go to find out. Like, no, there's too many people. Yeah, he's doing it. I told you, all the ultra Spencer. I'm glad I'm not up against them. But at the same time, like, right? Like, there's no one that's good to go. I'll see the door like this.
Kia ora koutou, we'll get underway. Just have a very small announcement from a student about a great event happening next week.
Oh my gosh, where's my script? Hi guys, I'm Cynthia. This is Nicole. We're from the Eco Justice Project, and we're just hosting an event with the Aotearoa Legal Workers Union about the reality of life as a junior lawyer.
So this session will be dedicated to understanding your rights as a legal professional and what you can do to help make the legal profession a better environment to work in and provide you with the knowledge you need to make your entry into the workforce a more enjoyable and equitable experience.
So this event will take place on Monday, the 29th of September from 6 to 7:30 p.m. at the Law School on Short Street. It will be in Building 801, Room 225. And you can go to our Instagram bio to register and for all the information you need. Thank you.
Okay. We are on to our second to last topic. That should be an exciting prospect for you. I can feel the excitement in the room already. All right, property. Now, property offences are surprisingly complex, particularly theft. So we're going to start with that first because it lays a good groundwork for you. But really, we're not going to get through much more than theft today. In fact, we may not even get through the whole topic of theft. So the four theft offences that we're going to be covering are theft, or stealing, so section 219, theft in a special relationship, which sort of plugs the gaps of theft, which, as you will discover, there are many. Obtaining by deception, which also plugs some of the gaps in theft, and then burglary. Now, if you look at the Crimes Act, there are many, many more offences, but we don't have time. I could spend an entire year on property offences, which would, for the most part, be fairly boring for you. Now, one of the reasons why these are difficult is because the origins of the law go right back to feudal times. Okay, right. So it is one of our oldest laws, and as a result, the law has developed over time, but we've just kept sort of adding on to what was quite a clunky sort of law designed to work in a particular environment, which is really no longer applicable. And as a result, we've ended up with a system that is really non-intuitive, which at times you're going to go, well, that makes no sense to me whatsoever. So I suggest that the best way to address this topic is to throw out everything you think you might know about theft and stealing and start again. And in particular, I want you to throw out the ideas of our common concepts of ownership and what it means to take something. Because if you start from a baseline of nothing, it's going to be easier for you to understand why the law applies in the way that it does in relation to theft. Okay? So not all of these offences are really non-intuitive, but theft in particular is, because it is the one that we have kept adding bits to. So to help you understand how the law of theft works, I'm going to go back to the origins of it. And you might be thinking, well, really, that's just incredibly boring. Why do I have to go back to hundreds of years? It will actually help you understand. So back in the day, in feudal times, everything was owned by the king or royalty or upper classes. Okay, if you were a peasant, you didn't own anything. You just got possession of things and the ability to use them, okay, or to work with them. And as a result, the law developed around those concepts of the king and royalty, or the upper classes owning everything. So it was built on this idea of possession and not ownership. And the other thing that the law revolved around back then was the idea of public sort of safety and preventing public disorder. Okay, so the state only intervened when there was the likelihood of there being some public disorder breaking out. The idea being that if you were wealthy and someone took your property, you should go to the civil courts and sue someone to get it back. Okay? But if something happened, somebody took your property and you immediately discovered someone's taken your pig, for example, they're trying to wrestle it out of your back garden, and you end up having a fight. Now that might lead to public disorder, that might lead to violence, and therefore the state might intervene in those instances. But otherwise, really, the state wasn't at all concerned with protecting your property, one, because the king owned everything, or the upper classes, and two, because if there were issues around someone taking possession of something you owned, or possession of something you had the right to use, then either the king just took ownership back, or you went to the courts, the civil courts, to enforce your rights. Okay, so the origins of the law, those two concepts of possession was more important than ownership, and that really the state only intervened where there was a likelihood of public unrest or violence, are the origins of why the law works in the way that it does, which is what makes it so incredibly non-intuitive nowadays, because our thoughts around ownership have changed so much. And we have this idea that if somebody takes my property, we phone the police. Somebody's broken into my house. I've been in this situation. They were really not at all interested. Somebody's broken into my house and they've taken something. Now, at this point, unless there's some suggestion that you might be likely to be in danger, they're really not that interested in coming. It could be a week, if at all, depending on what's stolen, as to whether or not the police will come and investigate. Okay, and part of that is the idea that we should actually have insurance, but also our law has developed and gotten so big with respect to theft that the police just can't really deal with everything. But as a person, our ideas around ownership and possession have changed so much that we have a different view on how the law should function for us than it used to operate back when this law originated. Something you might want to consider, just particularly in the concept of some of the things we're talking about. So last week, in terms of duress of circumstances, should property infringement always have a criminal justice response? And the idea being here, should we always be involving the criminal law, protect our ownership or our possession of something? So if you think about what's involved in the criminal justice system and how expensive that is, remember that it's your taxpayer money that is going to run the criminal justice system, and is it, particularly for small amounts of theft, is it wise actually for the criminal justice system to responding to small amounts of theft, or are we better to be dealing with poverty and putting our money and resources that way, particularly when, in looking at this diagram that comes from Max Rashbrook, where the way in which our wealth in New Zealand is constructed is apparently 1% own 22% of New Zealand's assets, and the next richest 9% own 37%, and down it goes. Right, so just something for you to think about. Now, as I said, we're going to be looking at two types of theft, section 219 and then theft in a special relationship, and you'll see that these two sections operate quite differently. And theft in a special relationship is actually a much easier one to grapple with, but as I said, it plugs the gaps of theft, which you'll start to appreciate are quite large. Now, looking at the actual section that deals with theft, that's section 219, you will see this is quite a big section which has a lot of things in it. I don't know about you, but I hate people reading things to me when I can see them on a screen, so I'll give you just a minute to have a read yourselves and absorb exactly what section 219(1)(a) and (b) says. Crikey, I'm getting some yawns already. I'm only just started. I know theft isn't particularly exciting. I'm doing my best. Okay, I'm hoping that what you have picked up from section 219(1)(a) and (b) is that you've actually got two different types of theft within the one section. You've got a taking. Okay, so you've got a dishonestly without claim of right taking property, and you've got a dishonestly without claim of right using or dealing with property. And they are two very different types of theft. And the first one, taking, is to do with possession, the idea of possession. So it's it really originates right back to feudal times, and it's about going and recovering something or removing something or just moving something from someone's physical possession. Right? So traditionally we would have thought of that as being something tangible, something you can touch, something you can pick up. And when you're looking at section 219(1)(b), you're looking at using or dealing, which is more about an ownership concept. Okay, so this is one that we have sort of tacked on to the idea of theft. And it means that I've somehow got possession of an item, of property, and then I've used or I've dealt with that in a way that is inconsistent with the rights of the owner. Okay? I've done something which has infringed upon their ownership rights. Okay, so they are two very, very different things, and you'll see when we come to have a look at some scenarios why you can't mash those two things together. So for those of you that are visual, I'm trying to give you a visual idea that these are two very different things, a little bit like homicide. They're different limbs of liability. Okay, you cannot just mash them together to try and make some sort of liability stick. They have different elements. They have different rules around them. So when you're looking at liability, you need to cite which section you're dealing with, whether it's section 219(1)(a) or (b), and follow the pathway down to establish liability separately for each. So let's have a look at our actus reus requirements for section 219. There's 4 of them. So the first thing is that it must be property. Now that sounds really quite simple, but actually as a starting point it can be extremely complex. And when you're working your way through these things, I suggest that you not skip over this lightly, because sometimes the idea of whether or not something is property is actually essential to the way in which you do your analysis. Now, obviously, you can't steal from yourself. So this is a common sense idea, but it's amazing how often students miss it. Okay, so the property must be owned or possessed by someone else. And you'll realise that sometimes there can be co-ownership, there can be partial ownership. Okay, but you do actually need to establish this particular actus reus. And you have to take it from someone's possession, or you have to use or deal with it. Okay, so the two alternative routes that I was talking about. And you have to do that without consent. Because if somebody gives you something and it is with consent, right, they intend to give it to you, they want to give it to you, it's their purpose or desire, then obviously you haven't stolen it. And we've got that is dealt with as one of the definitions. So let's work our way through this. Sorry, I'm going to do mens rea first. So mens rea, looking at our mens rea sections as well. Now you've got to intend to take, use or deal. You know what intention means. We've covered it over and over and over. It really fits into the dishonesty, but I just want to make sure that you understand that you do have to intend to take something or use or deal with it. Leaving the supermarket with a Kinder Egg in my handbag because my 4-year-old decided that he wanted that, and his mother should then exit the supermarket within her bag. It wasn't my intention to take it. You have to do it dishonestly, right? And we're going to look at what that means. You have to do it without claim of right. It's a weird expression, so we're going to unpack that. And you have to do it with an intention to permanently deprive. Okay? So we'll unpack all of those elements, hopefully today. Again, for those of you who are visual, basically there's your actus reus and mens rea requirements on one page. And you have to work your way through and prove, satisfy all of those actus reus and mens rea requirements to prove theft under section 219. Now, something to bear in mind, you don't have to prove a benefit to the defendant from having taken or used or dealt with something, and you don't have to prove loss or damage to the victim. You don't have to show that the property is valuable, although that will actually have a bearing on sentencing. You'll see, if you have a look at section 223, that the value of the property actually has a bearing on what the maximum sentence available is. You may remember, for those of you who had Bridget Taylor in your sentencing assessment, that I think she was convicted of theft for something under the value of, was it $500? Okay, that has a bearing on the available sentence. Right, so you can get a higher sentence if you steal something very valuable, but there's no need to actually prove value, and there's no need to prove loss. Now remember that particular fact, there's no need to prove loss. Okay, so working through our actus reus requirements first. We're going to have a look at property. Now property is defined in section 2 as including real and personal property, money, electricity, and any estate or interest in any real or personal property, any debt, thing in action, any other right or interest. Now you'll note that it says includes. Okay, so that is not an exclusive definition. One of the problems that has arisen in the criminal law with the advancement in technology is, what is property? When we've got all of this technological stuff happening, how do we decide what is property? And then how do we decide whether that property has been taken? It's become a real issue. Okay, so remember, Section 2, definition of property, is not exhaustive. Money and electricity, weird things. Okay, electricity in particular. You can steal electricity. If you plug in your neighbour's electricity to your house, you can steal it, but you can't steal heat. You can steal water. I used to live on Waiheke. You'd be surprised how often people would steal water in a drought. Hook up the hose to your neighbour's tank and siphon it out. Water is extremely valuable as a resource on Waiheke. A thing in action, you might think, what on earth is a thing in action? Right, a thing in action is simply something that has no physical existence, but the law acknowledges property rights in it. Okay, that means that you can go to the court and sue for it. Okay, so a thing in action is something you can sue for, sometimes called a shows in action. Now, previously, under the old law, property had to be tangible. Right? Go and steal the neighbour's pig, goat, fence, ladder. Now it can include intangible things. That becomes a much more complex thing to look at. And our idea of property is actually determined by the civil law. Okay, so which obviously we're not going to go into now, but where there have been expansion in the ideas of property, sometimes we have to look to the civil law to decide where they've said it's property. And for those of you that might go on to do property later in your degree, you'll see what that means and how we determine when property passes hands, etc. So one of the things in terms of looking at intangible information, so something came up recently about somebody walking into an office and seeing on the lecturer's, just might add it wasn't me, seeing on the lecturer's computer the exam question. As we're not allowed to print our exams, they all go into a protected file that you can't, it's extremely complex to try and get access to the damn thing. Right, so we can't print anything, we can't email anything, they're very, very protected. So this lecturer wasn't in the law faculty, I might add. Right, so this student walked in and saw this information on the lecturer's computer screen. Now, is it property? Right, so you took a photo of that. Is it property? Right, so it's information. Okay, and the court have ruled that information is not property. Right, so this idea of intangible things becomes very complex. If I tell you a whole lot of personal information about myself, right, and you then go and use that, it's not property. You haven't stolen it from me, you haven't used or dealt with it in a way that infringes my rights, because it doesn't meet the definition of property. Now, in the case of Davies and police, the court in that case had to decide whether or not internet usage was property. Okay, so this was 2007, a wee while ago. Employee was told he wasn't to use the internet for personal reasons, and he did end up using his personal computer and the internet to download music and various other things, and they charged him with theft. So they had to figure out, was the internet usage property? And the defence accepted that megabytes are a thing in action, okay, so they're an enforceable right, but that the internet usage itself was an action or activity and not property. But the court held that it was property, and it was stolen in the same way that units of electricity can be stolen, and therefore he was guilty of theft. Now, this was quite a famous case, and this is Mr. Dixon. This actually hit the international news. This involved an English rugby player who was married to a member of the royal family. I think it's the granddaughter, I'm not a royalist, I think it's the granddaughter or something of the Queen, or some great niece or something, or the old Queen. Right, and he was over here playing rugby for the English team, and they were down in Queenstown, and he was in a bar, and he was seen socialising with a woman who was not his wife, and then seen leaving the bar with this woman. And this was caught on CCTV footage. And Mr. Dixon, who worked for the security company, decided that he would download the security footage and put it onto a USB stick, and he intended to sell it. Now, he tried to sell it internationally. No one wanted to buy it, so he posted it on a video sharing site on the internet. And he was charged with a property offence, and the court had to decide whether or not this was in fact property. Now, this went all the way to the Supreme Court. So the district court held the data file containing the footage did fall within the definition of property, but the Court of Appeal said it didn't. They said it was pure information, and even though it was confidential, it was not property. And they said a computer file is essentially a stored sequence of bytes that is available to a computer program or an operating system, and those bytes cannot meaningfully be distinguished from pure information. They also thought on policy grounds that they shouldn't include information in property, including the need, because it would cause problems with respect to the freedom of speech. And they said if we start turning information into property, we will detrimentally impact the free flow of information and people's freedom of speech. So there were policy reasons behind there. Now, this went to the Supreme Court, and they disagreed with the Court of Appeal. So this is one of your readings that you've got on the reading list. Now, the Supreme Court sort of avoided the issue as to whether or not pure information is property. They sort of accepted that it isn't, but they said that actually in this instance the digital files weren't simply information, and therefore they did fall into the definition of property, irrespective of whether you consider them to be tangible or intangible property. And even though they contained information, they could be identified, they could be valued, and they could be transferred to someone else. They had a physical presence, albeit one that could not be detected by means of unaided senses. Right? So effectively, because it was property, he was then able to be convicted. Now, the court have made it clear that there's no property in a dead body. I think you look at Takamore and Clark. It is a civil case, but I think you looked at Takamore and Clark in first year. Yep. Humans aren't property, and that doesn't change when we die. So you can't steal a dead body. Now, there have been some international case law around this, and there have been convictions in the UK and Australia where it's been accepted that parts of a human body after the person has died have become property because that human body has taken on different attributes because of a process that has been done on the body, some kind of skill, such as dissection or preservation techniques, and they're used for exhibition or teaching purposes. I don't know if anyone saw the exhibition that was here a few years ago, but where they had the bodies, I think it was down at Wharf Shed 10, I think it was, or somewhere down there. And so these were human bodies that had been through a process that then allowed you to see the human body, the muscles, not just the skeleton, but the muscles, the nervous system, all of these things. Okay. And in one such case, overseas where people have stolen things, they have said that actually it could be theft. Now, in New Zealand, in the case of Re Long, they said it's unlikely that we will follow those international cases. And then we had this case of Police and Williams, right, which dealt with the theft of 2 toes, and I think it was from that particular exhibition. So these toes had become detached from this body, and they're quite sort of almost plastic in nature, not that I touched one obviously, but in terms of their appearance. Now he was charged with theft, right? So they had to decide whether or not these toes were in fact property. And Judge Hastings cited Re Long in the case and Police and Williams, and he said, look, to the police, because they charged him with both theft and they charged him with interfering with a dead body. He said, you can't have it both ways. It's either property, because it's not actually a human anymore, because of the process that it's been undertaken, or it is a dead body. Make a choice, right? So the police went a more secure route and decided to drop the theft charge. So the issue of whether or not it was in fact property wasn't decided. There are various rules around animals. I won't go into them. It would take too much time, but essentially you can steal an animal, but there are rules around whether or not it is something that is naturally wild, whether or not it's in captivity, whether or not it's you've stolen it from captivity or it's escaping from captivity, and whether or not it's considered to be a domesticated animal, etc., even after it's escaped. Okay, so there's particular rules around that. There is a course here about protection of animals run by Marcelo later if anyone's interested in that area of the law. Okay, actus reus number 2. We're looking at ownership. As I said, it has to be owned by someone else for you to be able to steal it. Now, we have a definition for this, and the idea of ownership is incredibly wide. So ownership is defined in section 2181, and a person can be an owner if you have possession or control of the property, any interest in the property, or any right to take possession or control of the property. Okay, so if the thing comes into your possession, then that means that you might be able to assert some kind of ownership over it. So we're starting to really merge the ideas of possession and ownership from back in the day in a way that perhaps wasn't intended, and really broadens this idea of who owns something and when you can steal it. So that means if you leave something with someone as security for a loan, for example, that means that they may have some ownership. I'm going to leave you my car while I borrow your bike because I'm going to go on a bike race. Okay, that means you potentially might be able to assert ownership because you've got possession. Now, in Queen and Saxton, they were looking at customary rights and whether or not customary rights could be used to establish ownership. And one of the issues that arose there was whether an interest in the property could include an interest arising from tikanga Māori. And the answer there was that it seemed that customary rights that hadn't been extinguished by statute, i.e. they continued to exist, could therefore be covered by the law of theft. So in that case it involved, from memory, the theft of greenstone, and there was the question of whether or not there was ownership because of customary rights. So just to wake you up a little bit, because you all look absolutely bored. I know it's not a particularly exciting topic, but it is nevertheless an important one. Right. I go to the pawnbroker. I know it's not a common thing for you to think about, pawnbrokers. You don't see them very often. They are still around. Right? When you go to a pawnbroker, you leave them with something. They give you cash, the idea being that if you can, you go back and you pay to get the item back. All right? So it's essentially giving them something to get cash, but there are terms upon which you are entitled to go and get it back. Right? So you pledge that you will come and get it back, and I fail to meet those pledge conditions. I break into the pawnbrokers to get my ring back, because I'm saying I own it. Have I stolen from the pawnbroker? What do you think? Yes? Everyone's nodding. Why have I stolen? Why, it's mine. Why can't I just go get it? Sorry? So what sort of ownership have they got? So you're saying they've got some ownership of it? What is the ownership rights that they have? Oops. Yeah, so they've currently got possession. I've gone and taken it. So you're correct in saying that that it's possession, but it's not a right to take possession because they've already got possession, but you're correct in saying they've got possession. Is there any other kind of ownership? Yes. Yeah. Right, so they've got that as security. Okay. So there's two ideas of ownership or concepts of ownership there that they can rely upon. So yes, I would be guilty of theft, okay, if you can establish all the other things. Right, co-ownership. Right, so you can steal from someone who was a co-owner. Okay, so if you are in a flatting situation, you buy a fridge. Okay, you fall out with your flatmate. You move out, you take the fridge with you, you could be guilty of theft. All right, because you are a co-owner. Now, Section 222 makes it clear that you can also steal from your spouse or your civil partner. What about abandoned property? Okay, can you steal abandoned property? So that's not a very helpful clock, is it? 6:58. I don't think I've been talking quite that long. Okay, what about abandoned property? So the general rule is that if property is abandoned, okay, abandoned means that the person has relinquished all physical control and given up all property rights in relation to it, it can't be stolen. Okay, but there's a difference between something that's abandoned, okay, so it's got no owner anymore, or it's been lost but there's still an owner, we just don't know who it is. Okay, now if it's lost, it can be stolen, where if it's truly abandoned, it can't. But because we've got this extremely expansive definition of ownership, it's rare that we can ever say that property is actually abandoned. Now, you don't actually need to know, if something's lost, you don't actually need to know who the owner is for you to steal it, okay, for it to be theft. It can be an unknown person. Now, in the case of Williams and Phillips, it's quite an old case, it's 57, so yeah, we're going back in the day. But these guys were doing a rubbish collection and they were pulling out of the rubbish rags, wool and metal, and on-selling them. And they were charged with theft. And they said, but it was rubbish. It was abandoned. And they argued that all claims to it had been relinquished. But the court said, which seems really unfair, to be honest, the householder retained possession of those items until they were picked up by the rubbish collectors, at which point they became owned by the local authority for whom the rubbish collectors were working for and acting on behalf of. So while the owner didn't want the property and put it in the bin showing that, the corporation could still come along, so i.e. the local council, local authority, and take it. So it wasn't, in fact, abandoned. The local council had a right to take possession or control of that rubbish, and therefore they had ownership. So the only way you can really say that rubbish is abandoned is if you put it out on the street and you put a sign saying it's free. Now, I don't know if anyone's ever been involved in an organic collection where you put everything out for the idea being that the council comes along, and lots of people go around and pick through those things thinking, oh, I could do something with that. It's my husband's worst nightmare, because I was like, oh, yeah, I'm sure I could sand that table down. We would end up with this huge collection in our shed. Right, so technically I was committing theft because actually it was out there for the local collection, the local council to come and collect. I mean, it's very rarely ever actually enforced, but it is actually theft. Now, when you're looking at lost property, you can also have a situation where it's lost but no one knows who owns it, and it doesn't even necessarily have to be on the property or the land of the person who originally had ownership or still has ownership but doesn't necessarily have possession or control. Okay, and this came up in a case involving a golf club, and so these guys were coming onto the golf course, right, and they were finding golf balls, and they were then selling that had been lost. Well, I presume they were lost, and they were selling them back to the golfers. Now, my brother used to do this. There used to be a creek along the golf club, on the side of the golf club or the golf course where we grew up, and they would go and dig along the banks of the creek and pull out these golf balls and sell them back to the people in the golf club. Now, in the Hibbert and McKinnon case in 1948, they charged these guys with theft. And they said that the private golf club had a special interest or possession of the golf balls. And even though they didn't know that they were sitting on the land, how many they were, or where they were, or who owned them, they nevertheless had a power over those golf balls, and they could have excluded anyone's right to possess them by, I guess, having security guards, etc., and accordingly they could be stolen. Now, this was applied in the case of Queen and Elum in 1997. This involved Rimu logs in the base, sort of in the bottom of a lake bed, which was under the control of DOC. And these guys, tourist development, decided that they would pull these logs up and use them, pull them up from the lake bed, and it was determined that they weren't abandoned. They were, in fact, still within the possession or control, the ownership of DOC, because they were the ones that had the stewardship of the lake bed. Okay, so effectively applying the same concepts of Hibbert and McKinnon. Right, so you can see just how wide the concept of ownership is, right, and just how widely the court is prepared to interpret it, even in very minor situations. Now, before we get into taking, using or dealing, we'll take a break. Should we say 10 minutes? And you all look desperate to make it stop. 10 minutes and we'll get back into it. Okay. I'm loving some of the questions I'm getting in the break, which is showing that your heads are really starting to think where this law can go or not go. Here's a question for you, and I don't know the answer. Is cryptocurrency property? I don't understand cryptocurrency, but something to think about. Okay, so we're going to get into our third actus reus element, taking or using or dealing. And remember, these are two alternative routes. Now, taking is looking at the unlawful interference with possession. Easy when you're thinking about tangible property, not so easy when you're thinking about intangible, right? Tangible being something you can touch, move, intangible, not so easy. Using or dealing is what we used to call conversion under the old law. So there was a massive change in the law in 2003, a lot of reform in the law of property to take account of huge changes in technology. I was just telling someone that when I used to teach property, it was before the birth of the internet. Yes, there was such a thing. It was easy to teach property. It was not a complex subject back then. But so when we're talking about using or dealing, you'll also sometimes hear people talk about conversion. That was what we used to, that was the old terminology for using or dealing, and that means that you've come into possession of something. It doesn't really matter how, possession or control. So even if it's by trickery, and you use or you deal with the property in a way that is inconsistent or in contravention of the rights of the owner. Now, a couple of tricky things to look out for. You can't be deemed to have taken something if you were given consent to take it. Okay, so if you get possession with the consent of the owner, it's not taking. Okay? Even if that consent to give it to you is as a result of deception or by trickery. Okay? So always remember that. Even if the person gives something to you, they intend to give it to you, even if you've deceived them to make them give you possession, if they consented, then it's not taking. And you can't use or deal with the property in contravention of the rights of the owner if at the time you take possession, you also get ownership. Okay, so if at the time you've got possession, so the person gives you something with consent, and with possession, ownership passes as well, then because you now own it, you can't use or deal with it in a way that is inconsistent with the rights of the owner because you own it. So those are two things to look out for, because they're the two tricky things in relation to taking or using or dealing. So the idea of consent is codified in section 219, subsection 4. Theft is committed by a taking when the offender moves the property or causes it to be moved. But it's not taking if it's done with consent, even if it's by deception. So if I scam you into giving me something, I still haven't taken it. However, consent must be freely given. Okay, so if I use violence or a threat of some kind, then it's not given with true consent. Okay, and at that point you then start to move into other offences of things like robbery, which is really just theft with an assault or a threat of assault. Now, I'll deal with this in a minute, but consent also can be vitiated by a mistake, but only in very limited circumstances. When we talk about using or dealing, as I said, also that includes conversion. So what you need to remember is that you use or deal with property after obtaining possession or control over it in whatever manner. Okay, so even if you've got possession or control by deception, if you then use or deal with it in a manner that's inconsistent, that can be conversion or using or dealing. Okay, but you have to get possession or control first, and you'll see why that becomes important when we start to look at money moving around in the banking system. And we don't really have a clear definition of using or dealing, so it's not defined in the Act in the same way that taking is. But the clearest definition you can draw from looking at the cases is using or dealing with the property inconsistently with the rights of the owner and without their consent. As I said, it used to be called conversion. There's unlikely to have been any real change in the way that we interpret the law. But just remember, if you're looking at old cases where they talk about conversion, and some of the examples that I'm going to give you, we talk about conversion. There doesn't, even though they call it using and dealing now, there doesn't seem to be any real change. So I'm going to give you a couple of examples too, where they actually said it was using or dealing, and two where they don't. The first one is police in Zabritsky. Now, this was a situation where the defendant was in a toy shop and she was walking home, and at some point she realised that her daughter was pushing a little doll's pushchair. Now, you wouldn't notice your child was pushing a pushchair that you didn't have before, I'll never know, but there you go. She carried on walking home, and when they got home she allowed her child to play with it. So she hasn't taken it. Right, the child took it, and she hasn't taken it without consent of the shop because there's no conscious taking, right? But she basically comes into possession of it innocently. So you're not looking at taking, you're looking at using or dealing, or in this case it was conversion because it was an old case. Now, what happened was she allowed her child to continue playing with it at home, and at some point the police turned up, and by the time they did, the pushchair had become quite grubby, or it was in a state now where it couldn't be returned to the shop. And they said that it was conversion. She had used or dealt with it in a way that was inconsistent with the rights of the owner being the shop. Ownership hadn't passed to her, and therefore she was guilty of theft. Now, using or dealing can also apply in situations of bailment. You go and you hire out a trailer or something like that. So in this case, this guy hired out, in Quinn and Russell, he hired a air compressor, and he got it home, and the guy in the shop thought, well, there's something a bit dodgy about this dude. So he took down his number plate. Now, he never took it back. We didn't take it back when he was supposed to. When the police turned up, they found that he had painted the air compressor. So he'd painted over the hire company's logo with grey paint. Right, and they said that that was inconsistent with the rights of the owner. And even though he had not taken it, right, because it was given to him with consent, he had used or dealt with it in a way that was inconsistent. In the case of police in Moodley, this was obviously a case where they just were really trying to get this guy. I suspect they thought he was some kind of terrorist or something. So there was a bookshop called the Resistance Bookshop. It was sort of anti-establishment, and they had gotten hold of a police manual, and there were people on the premises that had taken part in a police protest, and the police, when they came onto the bookshop premises, they found the manual, and it had been thrown in a drawer, and they said that they argued it was using or dealing. Not sure why they didn't argue taking. Obviously, it must have been given with consent, because it had been used inconsistently with the rights of the owner. And the court said no, that didn't apply. All he had done was put it in a drawer, and there was nothing to suggest that there was anything beyond that to say that it was used inconsistently, the property could be returned. Now, in Broome Police, this guy's just an idiot. in Broome Police, so this guy found out that there was money being offered for a stolen bike, and when he realised that he could get the reward money, he offered to sell. He had tried to sell this bike for money much less than the reward money. And so he decided, right, rather than actually trying to sell this thing that had come into his possession, he thought, I'm going to try to get the reward money. So we contacted the guy offering the reward money, and he said, look, I can get hold of your bike. Are you sure you'll give me the reward money? And the guy said, yes. And he said, right, I'm going to return the bike to you in pieces. I mean, the effort to do that. So if you go to this place, you'll find this piece under this, in this place, and put some money under a rock. And then you're going to have to then go to that place. And so he was trying to ensure that he got all of the reward money by holding on to the various pieces of the bike. Now, you can imagine how pissed off the guy was who just wanted to get his bike back. So we went to the first place. The owner went to the first place, and he got the bike piece, and he left a pile of chopped newspapers there rather than the money. And then they nabbed the guy and they charged him with theft. Right? So the court said no, it wasn't using or dealing with the bike contrary to the rights of the owner, because the owner had consented to the manner in which he was trying to get the reward money, right? He had consented to this idea of the bike being broken up, and that he would then go to these various places and collect the bike and pay this money. So it wasn't using or dealing. Now, as the owner, you'd be well pissed off with that result. Okay, but it wasn't using or dealing because he had consented. It's not inconsistent with the rights. Now, as I said, the other tricky thing about using or dealing is if ownership has passed with possession, you can't use or deal with the property in a way that is inconsistent with the rights of the owner. So the question you've got to ask yourself is, when does that actually happen? When does ownership pass with possession? And the general idea is, and it's predominantly governed by the civil law, but the general idea is that the voluntary delivery of possession, so the voluntary provision of the property, means that the intention is that ownership will pass if it is the intention to actually transfer ownership. So obviously in a bailment situation there's no intention to transfer ownership. But if in giving you something, okay, if I voluntarily given you possession and I intend to give you ownership, then it is assumed that I have in fact passed ownership to you. There is an exception though, and that relates to fungibles. Now, that's a really strange word. What is a fungible? Now, a fungible is a thing that is an interchangeable unit. Okay, so basically we don't really care which of those things we get, they're all the same. If I lend you $5, I don't expect that $5 back. As long as you give me $5, I don't care that it's a different $5. Okay, that's a fungible, right? It's an interchangeable unit. It doesn't have to be the same thing. And with fungibles, it is always the case that ownership passes with possession. So your first question has to be, is this thing a fungible? And if it is, then ownership will have passed with possession. If it's not a fungible, was it the intention of the person to transfer ownership? Okay, so another example of a fungible is petrol, for example. When you go to the petrol station, okay, you don't care, except for whether it's leaded or unleaded, 91, 90, what's the other one, 95, 96, whatever it is, the expensive one. All right, you don't, you all laugh at me like, yeah, okay, that's fine. My car takes 91. It's right, it's cheap. Okay, so when you go to the petrol station, the minute you put that pump in and you put the petrol in, it's a fungible, right? You've taken possession of it into your vehicle. You now have ownership of the petrol. You don't care, right? In terms of if they say we want the petrol back, okay, they don't want the same petrol back. But in fact, what happens with a fungible, because ownership is passed, at that point you've got ownership, you then just have a debt that owes to the petrol station. Okay, and the one thing you've got to remember about money is that it's only when money is operating as a currency. Okay, and the distinction is currency or, say, money that is a special coin which we don't use as currency anymore. So an old coin, right, an old Roman coin. It's money, but it's not something we use as currency. So remember, when thinking about whether or not ownership is passed, whether or not you're looking at a fungible. Now, what happens if there's a mistake? What happens particularly when you've got a fungible or where you're handing over property and you intend to give ownership, or you thought you intended to give ownership and there's some kind of mistake as to what you've handed over or how much you've handed over, or you give it to the wrong person. Okay, is it always the case that you say, well, you've got ownership, it's too late? If it's money and I give you too much, I've given you possession, you've got ownership, it's now a debt situation, what happens then? Okay, so we have to then consider, when does a mistake make a difference? And some of you might remember the case of Leo Gao and Kara Hurring, and this one hit the international headlines. And this was a situation where Mr. Gao applied for a business loan. They were in financial difficulty, and he applied for a bank overdraft of $100,000. Somebody in the bank made a very, very, very big mistake and gave them an overdraft of $10 million. Imagine having to go to your boss and explain that one. Now, Mr. Gao and Ms. Hurring decided to do a run with all that money, and they transferred most of the funds offshore, and then they withdrew cash in a number of EFTPOS transactions, and they disappeared for ages overseas. Okay, they eventually, I think she returned home with her child voluntarily, and then he got extradited. And they were charged with theft. Now, if you think about it, the money is transferred into their account with consent. Okay, so the person did all the operations to transfer that money into their account. That was done with consent. Yes, there was a mistake, but it's currency, it's money. Okay, so at the point that they take possession of it, they take ownership. So what does that mean? Now, I think she may have pled guilty. No, he pled guilty and she was found guilty by a jury. Okay, and this raises real issues around how our law operates, because this case has come under a substantial amount of criticism, because when you look at the way in which transactions happen online, you'll realise that the result of her being found guilty, I think, is, if you look at the law correctly, is wrong. Okay, and if you look at I've put this as one of your readings, Getting Lost in the Borderland of Theft. So this is from one of the old professors here, Peter Watts, and someone anonymous, they didn't even want to put their name to this, where there's a great deal of criticism about the case, saying that basically this should never ever have gone to trial. They should never have been charged with theft, and certainly never convicted of it, because ownership passed, title passed once the money hit their account. It then became theirs. So anything they did with it after that could not be using or dealing. They can't have taken it because it was done with consent. So how can it be theft? So does the mistake made by the person in the bank make a difference? Wasn't their mistake? Now, there's no question that from a civil point of view that they owed the money back to the bank. Okay? There's no question that this was a civil debt, that they owed the $10 million back to the bank. But was it actually theft? Okay, and if you look at the correct construction of the law, I would have said it wasn't. And if you read Peter Watts's article, that will help you to understand that if conceptually you're struggling. We will have a look at online transactions in a minute, but you'll see how difficult it is, and you can imagine a jury trying to grapple with it as well. Now, in England, they've plugged the gap that we have here in New Zealand by basically saying where this happens, the person was responsible to restore the funds, okay, if there's a mistake by another person. So they've plugged the gap with legislation as opposed to us who's just actually tried to fudge the law and pretend that the law doesn't operate in the way that it should if you understand it. But we have yet to do that. Now, we've got an Australian case that probably I think most accurately describes when a mistake should properly vitiate consent. So where ownership has been supposedly given with possession, but there's been a mistake. And this is the case of Illich. And in that case, they said there will only be 3 situations where a mistake actually vitiates consent. And this was a case involving a vet. And he was a locum guy, and he was overpaid by $530. Okay, so his employer gave him an envelope with cash in it, and so it had $530 too much. It was a mistake by the person paying him. He didn't realise until he got home later, and they charged him with theft. Clearly they didn't want him back. And the question was whether or not this was theft on his part, or whether or not, in the sense that the mistake made by them vitiated consent, or did the rules around fungibles apply in the sense that when you give possession, ownership passes, and therefore the mistake made no difference, because it wasn't a mistake that vitiated consent. And the court said, the High Court of Australia said, there's only 3 situations. Mistake is to the identity of the transferee. Okay, so you're giving it to the wrong person. You think you're giving it to someone, you think you're giving it to John, but you give it to Jack. Mistake is to the identity of the thing handed over. I think I'm giving you a book relating to theft, and I give you a book relating to larceny. Or a mistake as to the quantity of the thing handed over. I think I'm giving you 3 things and I give you 4. Except, okay, and this is where it becomes important for the sake of the vet, except where you're dealing with money, where there's a mistake as to the quantity handed over with money because it's fungible. Okay, special rules apply to currency. Ownership passes with possession in this case, except where the transaction isn't bona fide or for value. Okay, so if the vet had got the envelope and opened it and gone, oh, there's an extra $530, when he received it then and there, you would have said it's not bona fides, it's not in good faith. Okay, so that would have vitiated the consent. Except that didn't happen until much later, and so therefore all that was created was a debt situation. Okay, so we've got very strict rules around when mistakes will vitiate consents. So if you think back to the Gowan Hurring case, and you apply the same rules, you can see why it shouldn't be theft, hopefully. And we've applied this in New Zealand and police in Dronjak. This was a guy who wanted to buy a stereo. There were 2 tags. He removed the more expensive tag, went up to the counter, person rung it up, he paid the money, walked out the door, and they charged him with theft. And he's argued, quite rightly, that he didn't take it because it was given to him with consent. and he couldn't have used or dealt with it inconsistently with the rights of the owner, because at the point that he was given possession, it was the intention of the person giving it to him to pass ownership, and therefore he can't be guilty of using or dealing. Okay? Now, electronic transfers, this is where it gets really tricky. And I've tried to do some diagrams to help you with this. And this is where we're talking about a thing in action, or what's sometimes called a shows in action, okay? The right to sue for something. And this came up in Wilkinson. Now, this is an old case, so this is pre-2003 reforms. And what happened in that case was a financier a defendant had falsified some documents to use a loan or credit facility from a financier. So the financier lent the money, which was done by way of an electronic transfer. And the question was whether or not that was theft. Okay, it had been done on the basis of a false representation, so deception. Is it theft? Okay, had it been taken? Had it been used or dealt with? And the court said there'd been no transfer, even though there had been a change in the contract between the financier and the bank, and the bank and the defendant. So that looks like this. Okay, so the first thing is you've got this loan contract between the defendant and the financier. Financier gives instructions to the bank to loan the money. Okay, the money, we think of it as transferring, but nothing actually happens. All that happens is there is a change in the contract between the financier and the bank, and the defendant and the bank also has a change in their contract. Okay, so that's what the court said in Wilkinson, but pre-2003, a thing in action was not property. Okay, so the issue is, has the law changed? Do we have a different situation now that a thing in action is now deemed to be property? And we don't, in my view, because nothing has changed, nothing has been taken, nothing has been used or dealt with. And this is where we come back to this idea of what is taking, what is used or dealing, back to the old concepts of how the law works. And you also have to understand how electronic transfers work, in the sense that this is all happening electronically, but nothing moves. Okay, we have this idea that when somebody transfers money that it goes from one account to another, but it actually doesn't. So just taking through the steps of this, your first step being, say for example, you've got a defendant who's got $100 in their bank account, and you've got a victim who's got $500. Okay, so the victim has the right to go to the bank, a thing in action, and ask for or demand, I want my $500. That's the thing in action, the right to sue or to demand from the bank $500. That's all they have, right? The defendant, in turn, has the right to demand $100, because that's what's in their bank account, that's their thing in action. Now, say for example there's a loan agreement between the defendant and the victim. The victim instructs the bank to transfer the defendant $100. Okay, so Wilkinson scenario, I want you to give this person money. Nothing actually moves. Nothing is taken. Okay, so what happens is the victim's contract with the bank, the thing in action, the right to demand money, goes down to $400. The thing in action between the defendant and the bank goes up to $200. But nothing has moved, nothing has been taken. Okay, there's no transfer. We think of money moving between accounts, but it doesn't actually happen. There's just a change in the contractual relationship between one party with the bank and the other party. Can you see that? Can everyone see that? I'm hoping that with my little diagram that you're grasping that. Now, what happens if the defendant then withdraws his $200? You go, well, surely that's theft. Okay, so this is what Gow and Herring did. They took the money out. But because it's currency, ownership passes with possession. It becomes theirs, or the defendant's in this case. You take the money out. All that happens is your contractual relationship with the bank has changed. Okay, it's now zero. Nothing's happened with the victim. The victim's still only got $400 that they can demand. You can't get charged with using or dealing, can't get charged with theft for using or dealing because you now own the money. So when you take the money out, it's yours. So even though we've had this change in a thing in action, I don't think the law has changed at all in terms of financial transactions. The thing in action is property, but it hasn't changed anything with respect to theft. Now you might say, but there's a loss. The victim has suffered a loss. The victim has lost $100. How can that not be theft? But Section 219 isn't concerned with loss. It's concerned only with taking or using or dealing. So when we get to look at Section 240 and we're looking at obtaining by deception, then we get to talk about loss. Is everyone following? Okay, brilliant. Okay, right, mens rea. How are we going for time? That doesn't help me greatly. 7:54. Right, mens rea elements. Remind you again. How's everyone going? Yep, few nods. No one's fallen asleep that I can tell. Won't comment on some of the expressions on your faces otherwise. All right. Okay, we're on the home stretch. We're on the mens rea. Now, intend to take, use or deal. All right, just intend, talking about purpose, desire, virtual certainty. Okay, don't need to go into that greatly. Dishonestly. Is that a hand up or a stretch? Never go to an auction, you just bought a house. Okay, so let's look at dishonestly. Dishonestly is defined in Section 217. Is done or omitted without a belief, there was express or implied consent or authority, right, to do the act or the thing from the person that was entitled to give that consent or authority. Okay, so if you're the prosecution, you've got to show that this person did it without believing, and it's subjective, that you had the consent of the person who was entitled to give it. Now, remember that this is entirely subjective. So, essentially what the prosecution is having to prove is, and remember it's beyond a reasonable doubt, is that you didn't believe you had legal authorisation from the person. Okay, so if you thought you might have had implied consent, as long as you genuinely believe it, and the person thinks you're telling the truth when you give that evidence, okay, that's going to be sufficient. Obviously, if your evidence is a little bit outrageous, then that might suggest that you're not telling the truth, but it doesn't change the fact that it's a subjective test. Under the old law, so pre-2003, we used to talk about fraudulently. And fraudulently was actually quite different to dishonestly. It was something less than dishonest. It sounds worse, but in fact, you could rely on moral dishonesty. Fraud was interpreted as moral dishonesty, whereas now we talk about more concepts of legal dishonesty. Right? So if you could say, well, I thought I was morally authorised, then you weren't fraudulent. Now we have to say, I thought I was legally authorised. You might think, well, really, is that such a big deal? But when we look at a case, an old English case, you'll see why this might start to become a problem. Now, this was a guy who, I think his wife was trying to get a taxi. I mean, obviously, it's an old case. He was trying to get a taxi, and the taxi driver didn't have didn't have change for the amount of money that he had. So he was trying to call a taxi for his wife, and so he grabbed 40p out of the till with the intention of giving it back. And he said, you know, I thought that that it was okay. I didn't have anyone to ask, that there was implied authority that would be okay, that I wasn't doing anything wrong, and the court charged him with theft. He was charged with theft, and the court said, essentially, that they couldn't really imagine a case of where this would be something that is worthwhile, of actually saying that what he was doing was so bad that you could have said it was theft, and that we should actually punish him for something like this when he thought what he was doing was not morally wrong. Okay, the intention being that he would put the money back, but he knew he didn't have consent to take it. Because he doesn't have consent to take possession, ownership doesn't pass, and therefore you can't say that just by putting the money back that it's a fungible, because he's enforced a substitution. Right? But the court said that it's not fraudulent, so he wasn't guilty of theft. Now, under our new definition, dishonestly, it would be. Okay, so somebody's going out the door, or they need to pay, you know, pizza delivery guy turns up, flatmate's got $20 on the bench to pay for something else, and you're like, oh, yep, no worries, I'll just use that to pay them, I'll give them back $20 later. Okay, under our new law, dishonestly, it would class as not having legal authorisation. Okay, you know that you are dishonestly taking the money because you know that you do not have the consent, unless you could argue implied consent. So, under the old law, we could have said we're not going to morally judge you for that, but under the new law, we say, well, actually, we look at the legal situation, you have been dishonest. So we are slowly tightening up this law on theft continually in the way that we interpret it. And the same applies for claim of right. So, claim of right is defined in section 2. And claim of right is different to dishonestly because claim of right is about a belief, and again it's subjective, that you had some kind of proprietary or possessory right in the property. So this is about coming back to sort of the idea of ownership. I thought I had some kind of ownership in the property. Now, if you think, how is that different to dishonestly? An example I could give you is, say, I borrow a ladder from my neighbour. No, actually, I'm going to go the other way. I'll lend my neighbour my ladder, and I ask for it back, and he says to me, I've given it back to you, I put it in your shed. I can't find it in my shed because I've got too many things off the side of the road from the inorganic collection. And so I think he's lying to me. He's got my ladder, I can see he's got a ladder leaning up against his house. It's exactly the same as my ladder, I think. He's still got my ladder. He goes out, I go across to his house, and I take what I think is my ladder. Am I being dishonest? Do I know that I have consent? Dishonestly is about consent. Do I know I've got consent? Let's go back. Am I dishonest? Yeah. Okay, I know that I don't have his consent to take it, not expressly or even impliedly. He said, no, that's not your ladder, I've given it back to you. Do I have claim of right? Do I think I have a right to the property? Do I think I have some proprietary right of ownership? Yeah, because I think it's mine. Okay, so I have the ability to argue claim of right. Now, even if I'm mistaken, okay, so make sure you remember, so when you're looking at claim of right, you've also got this mistake concept. So you can argue claim of right even if your belief is based on ignorance or mistake of the law, provided it's not mistake about what you're charged with, i.e. theft. Okay, so you can see the distinction between dishonestly and claim of right. I know I don't have consent, but I think I have a right to take it because I think it's mine. Turns out it actually is his ladder. My shed is just a mess. But I'm not guilty of theft because I had claim of right. Okay, so remember, you've always got this mistake is the rider to it, provided you can show that it's a genuine mistake, right? Because it's subjective. Now, under the old definition, we used to call it colour of right. Okay, and again, we have tightened the law up. So under colour of right, the definition was much more expansive. And you didn't have to show that you thought you had an ownership right in the property. You just had to show that you thought that what you were doing was lawful. Okay, I thought that what I was doing was a lawful thing to do, but I don't have to establish I had any kind of proprietary or possessory right. Okay, and this, one of the most famous cases dealing with this was the case of Leeson and Attorney General, which you may remember from defences. So this was the guys that went in and punctured the dome of the security dome down in Waihupai. And they argued that what they did was they had colour of right. Okay, it was lawful. So they were essentially saying, well, we thought that we had a legal right to do this. We thought we had a defence of duress of circumstances, and therefore what we did was lawful. And the court accepted that. Okay, they said they had colour of right because they believed that what they were doing was lawful, even though they were mistaken as to whether or not the law applied to them. We then tightened the law up so that now there's no way they could claim or could have relied upon claim of right, because there's no way they could claim any sort of possessory or proprietary interest, any lawful proprietary interest or possessory interest. Okay, so we're tightening the law. Now, that pretty much, according to my clock, brings us to the end. So I'll finish the mens rea elements next week, and then we'll do theft in a special relationship, and you'll see that plugs the gaps, right? Thank you for bearing with me. I know it's not the most exciting topic. Dear, how are you?
Good, how are you?
Good.
Just a question about the last lecture. So that was duress of
Yep.
circumstances.
Yep.
There's a limitation that threat must not be a result of the decision.
Yep.
We didn't really go into detail. Could you explain it a little bit?
Well, so basically,